Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Welcome to episode 13 of the Mineral Rights Podcast. Thank you so much for joining us. My name is Matt Sands, and I'm here to help you make the most of your mineral rights and royalties. Today we have Spencer Cox, who's an attorney with Burns Charest. He's going to help us dive deeper into the world of royalty audits and when litigation might be an option for mineral owners to pursue. As I've mentioned before, we are running a contest for anyone who leaves us a review on iTunes. Just go to mineralrightspodcast.com/contest to enter. Anyone who's already left us a review is also eligible, so don't worry, just be sure to enter. And I'll be giving away a free mineral rights consultation, which includes phone and email access to me, along with my time to help you make the most of your minerals. This could include getting evaluation of your minerals if you're looking at trying to negotiate a sale and want to know how much they're worth, assisting in reviewing lease offers, or anything else that you might need. This includes up to 4 hours of my time, which is an $800 value. The contest ends on 12/31/2018, so if you're listening to this before then, please enter. So let's not wait any further. On to our episode with Spencer Cox.
All right, so our guest today is Spencer Cox with Burns Charest, and he represents individuals and businesses in complex litigation situations inside and outside of mineral rights. Mr. Cox, kind of a little background on you for our listeners. You were born in Texas. You attended high school and after graduated served with the U.S. Navy as an aviator and a flight instructor with the F-18. You have more than 400 arrested carrier landings. And after serving in the military, you went on to Harvard Law School, where you graduated and then worked with somebody in the District Court of Massachusetts. That's a pretty amazing resume, Spencer, if I may say.
Thanks. Yeah, that's sort of the quick outline. I've been kind of lucky to be in the right place in the right time and meet some good people, and have had a lot of fun before law school and having some fun now.
And if you don't mind me asking, Spencer, what is a normal day for you? I know mineral rights is not the only thing that your firm represents. Do you spend your days typically working on caseloads that you have, or talking with clients, or what is a typical day for you?
It's a little a bit of all of the above. It's hard to say what a typical day really is. It sort of depends on what's the most pressing thing before you that day, and then of course little fires are going to pop up here and there. I think mostly I spend the majority of my time either dealing with clients or, researching or writing, motions in litigation and whatnot. But there's also, a small amount that's out there researching potential new cases, and then, seeing what else is out there that we might be interested in getting involved in.
Absolutely. And I know we've talked, Spencer, that there's a lot of information that we bring to our listeners. And with everything with mineral rights, it seems like you can touch just on the surface and you can go deeper. So we're really glad to have you and be able to pick your brain on some of these things. And I'm just going to kind of dive right in. Being born in Texas, Spencer, was mineral rights something that you were always aware of? Was it in your family, or was it something that you just professionally kind of ended up in?
A little bit of both. I think some of it was family based even before I knew that I was wanted to go to law school. I had my grandfather on my mother's side. I guess the family story is that back in the Depression, he would do work for folks, and if they couldn't pay him, they might pay him with a partial assignment of their minerals. And so through that, the family kind of acquired a little hodgepodge of mineral rights in western Oklahoma, and that's sort of passed down, through everyone. And of course, we don't really hold anything that's particularly big, but it was sort of neat growing up to think about, okay, well, if he had 1/8, and then, now we're at 1/32, and who's got half of that? And it's a little bit of a nerdy answer, but I always thought the fractions were kind of cool to play out in your head and see where you stood.
No, absolutely. And I think it's very interesting. I think it piques a lot of people's interest through it. When you were in the military, did you know that you were going to go into law when you were done? Is that something that came up? Or, when you were in the military and serving, was that just not even a thought in your mind?
No, it was, so my dad was a lawyer in a small town in eastern Oklahoma. He practiced in Hugo, Oklahoma, just had kind of a country lawyer deal, had his own office, and he did whatever came in the door. So when I was young, I found it interesting, and I thought that one day I wanted to be a lawyer too. And then along the way, I kind of got interested in flying, and that became an opportunity. But I always had it in the back of my mind that whenever I got done with flying, I wanted to go back to law school, and that was going to be my second career.
No, that's absolutely wonderful. And with Burns Charest, I know you're not the only attorney you guys have. What states are you guys licensed to practice in?
Actually, quite a few. We only have, I think we have about 15 attorneys right now. We may be up to 16. We've got offices in Dallas, Denver, and New Orleans. So that gives us Texas, Colorado, and Louisiana. I think that might be the most, relevant to mineral owners. But we also are licensed in California, New York, D.C., Washington State. Even have some attorneys who are licensed to practice in the Virgin Islands, which I suppose is great work if you can get it.
No, absolutely. Talk about being a niche attorney there. What is y'all's guys' focus? Do you guys have a couple focuses that you could give with your firm, or do you guys are pretty well rounded with what you guys serve?
We are not particularly focused, and maybe we should be more. Really, our focus is on plaintiff side complex litigation. So we do mineral rights cases, but we also represent working interest owners, operators, an international E&P company with some offshore drilling, and that's within the energy world. But we also we serve as lead counsel in a number of class actions, particularly with antitrust and competition cases. We're the lead counsel in a big litigation down in Houston following Hurricane Harvey. We represent the upstream landowners in that case. And then we also are pretty heavily involved in, like I said, antitrust, but particularly price fixing with respect to leasing practices, for one, which is kind of where the two worlds overlap. And then there's also a big antitrust and consumer practices case that we're leading that arises out of the EpiPen, which I think some folks may be familiar with. That's the allergic reaction epinephrine autoinjector. So a very broad field of practice, but the one thing that they usually have in common is that we're on the plaintiff side and that they're relatively complex.
No, absolutely. That makes a lot of sense. You look more for a case structure than necessarily a certain goal that you're serving. And, one of the things that we wanted to kind of bring to you is the royalty audit and lease law, because that's something that I think a lot of mineral right owners have questions about. And in past episodes, we've briefly touched on royalty audits and the importance of reserving the right to audit and doing so when the royalties come in. As a mineral right owner, I know that the lease law regarding royalties can be a very gray area, and it's not always as simple as reading the lease. What is the first step when a client comes into you and suspects that there's been deductions from their royalties, or they have questions, or where do you begin?
Well, we always like to start with the lease. The basic information we want is the lease, whatever check stubs the client might have retained. If they have production data that they've compiled or have access to, that's also helpful. And then, of course, we want to know where the property is and who the other owners are. But there are various issues that can come up that a mineral owner might have questions about or concerns. So usually you're going to find the answer in the lease, but it also, depending on your jurisdiction, there may be different state statutory rights that you can take advantage of as well.
No, absolutely. And once there is something, in fact, something to pursue with deductions and stuff, what is that something that typically you find it's time to establish a line of communication with the oil company? I think from speaking with you in the past, there is no really one size fits all prescription to that scenario.
Right. Sure. So so it's sort of a joke that your lawyer's always going to tell you that it depends and not give you a clean answer, but it does depend on a number of things, and primarily the initial route that you want to take or initial approach depends on how much time you have. That's driven largely by the statute of limitations in your jurisdiction. And what that is I guess the concept of a statute of limitations means that you've got legal rights, but you've either you have to use it or lose it, as it were. In other words, you can't just sit forever, without taking some kind of action. So depending on how much time you have left and what exactly your problem is, you may reach out first to the operator. That may be something that the landowner can do or the consultant can do. But typically, if someone is coming to us, they've likely already done that and not had a lot of success. So, we may use our contacts within some of the operators we deal with to see if we can, sort of get something done informally behind the scenes. Or if not, or if your time is running short, then you may have to think hard about whether you want to immediately go to litigation.
Absolutely. And, in your experience, I know we talk a lot about, but not often do the oil companies intentionally mispay people. And that's, I think that's kind of a rare scenario, but I think typically it's a mistake on both parts that people are willing to fix if the lines of communications are open.
Yeah, I think so. As you guys may know, there can be a lot going on in land department or division order, and occasionally you just have human error. Maybe, a typo is made in the way that a lease is coded or inputted into the system or whatnot. And those things can usually be fixed. Maybe there's some simple documentation that you can provide that will solve a title dispute, for instance. But in other cases, there are operators who will aggressively interpret leases to, in their favor to the maximum extent. And that may or may not result in a correct interpretation. And if you're asking them to do something that's going to require them to, really change a significant practice or pay out a lot of money that they would rather not, then it may be more challenging, as it were, to get that done informally.
Absolutely. And I think that makes a lot of sense. And if you don't mind me asking, is there a certain point where it makes sense to litigate? Obviously, if you're talking a couple months worth of royalties, it may not make sense to litigate. But is there, and again, it may not be a one-size-fits-all answer, but is there a certain point that it monetarily either makes sense or, it's time to see an attorney?
Well, again, it sort of goes back to the time issue. As you approach the end of that limitations period, that puts a lot of pressure on you as the owner to go out and I think seek an attorney and just at least get their an initial consultation so you know what your options are and what your risk is if you don't litigate, for instance. On the other hand, if you have some time left, depending on the amount of money involved and depending on what the negative consequences might be, you might be able to do other things outside of litigation, maybe employing some consultants who specialize in deductions analysis, for instance, to help you out. And of course, there's a flip side to everything, whereas it might only be a couple months of royalty payments, but if you're expecting that, hey, if you've got some great interest and you're expecting quite a bit of production that's going to be valuable in the future, it may make sense for you to go ahead and push the issue now so that it can be solved going forward and controlling, in the future, especially if it's a question of who is going to get paid royalties or for a certain interest as opposed to how much they're going to get paid.
Absolutely. And I know this is a question that if I was listening to the podcast, I would certainly be wondering, but what does a client-attorney relationship in terms of payment look like when you go into something like this? Is it typically a percentage of what you guys are going to get back from the royalties? Is it hourly? Does it depend?
Well, it really I'm trying very hard to say something other than it depends. But here, really, you want to look at the case size and on client preferences. Our preference as a firm is to generally take cases on a contingency basis. And for listeners who may or may not know what that means, it's basically we will. You're not going to pay us by the hour, but we're going to take some percentage of the recovery if there is one. And if there is no recovery, then we take nothing. But that's a very quick way to get an idea of how strongly a lawyer feels about your case, is whether they're willing to take it on contingency. Now, that may not make sense for some clients, and they may prefer to pay on an hourly basis. And in those cases, lawyers are generally open to that, and usually open to either. But it's certainly something that you want to discuss with your lawyer up front and be aware of what the pros and the cons of each one of those are. The end goal there is to make sure that your incentives and motivations and goals are, aligned properly with your lawyer, so that everybody's on the same page and on the same team going forward.
Absolutely. And I know the next subject we're getting into can really be a sticky one. And it's not often we hear from mineral right owners that are looking to either get out of a lease, or they inherited some minerals that maybe are under lease and they've received offers that are better, or whatever it is. And I know there's, again, no one size fits all answer in the scenario, but how often does it come across your desk that you hear from people who are looking to actually be released from a lease? Is that something that's pretty common?
It is not. It is not unheard of. I imagine it's probably uncommon with in the the greater world of lessors out there. But if folks who are coming to us are already unhappy for one reason or another, or at the very least they have suspicions that maybe they're unhappy with something about their lease. So it's not completely uncommon. We usually see people who think maybe the operator isn't operating right. They're wondering why their lease isn't producing the way it used to. They may have concerns about surface use. What's happening on the surface of the leasehold. And then others, it's more often than I say more. There are things called pew clauses, which I'm not sure if you guys have covered on the podcast before, but basically it may be that part of your leasehold is pooled into a producing unit, but the other part is not, and you want to get that unpooled portion released from the lease so you can go out and maybe get it with a different operator who is going to drill or produce on that acreage. So all those are reasons that folks might consider getting out of a lease, although kind of like you said, if the wells are producing and you're being paid, you're generally reluctant to want to terminate that.
Yeah, that makes sense. You mentioned a few of those examples. In terms of being able to successfully do that, what are some of the things that you look for in the lease, or kind of the circumstances that will enable you to pursue that successfully? Is it sort of a roll of the dice, or do you have any sort of guidelines you could provide?
Well, I think the first thing is that your lease may have very specific provisions that tell you when you can and when you can't terminate for different reasons. Aside from that, production and paying quantities is a big one, and what that really means is that if an operator has your lease, they've got to produce a certain amount to hold the lease past the primary term, and that's usually not a problem initially. But as wells get older, and as I'm sure you guys know, the production curve declines, you can end up with a situation where an operator is sort of just holding your lease by trying to barely produce from a well. Depending on your jurisdiction, you may or may not be able to terminate the lease if the well or the production on the lease at least is not profitable. And of course, there's all kinds of caveats depending on state law and things you have to look at. But sometimes you can have a stripper well that tries to hold a lease for a very long time, and if you feel like that you're being taken advantage of, or if there are others who are operating in the area and being more aggressive with their production than your current lessee is, that's something you may want to investigate.
Okay, thank you for that. And a lot of times I've run into a situation where you have leases that were signed maybe in the 60s or 70s, and different language maybe than we're used to seeing today. Are there cases where, in terms of the lease language itself and looking at those leases and looking at current case law, is that something where there is precedent for trying to get out of, or is it really just once you're in, regardless of sort of when you signed it, you're sort of stuck with it?
Yeah, I would say that it is oftentimes an old lease. It is absolutely not uncommon at all to see leases that were signed in the 50s or 60s or even earlier that are still held by production for one thing or another. Of course, there's lots of new technologies that come along and can keep a lease productive, even through the decades. And then the other thing I think is that these older leases generally tend to have lower royalty rates. So you more often are going to see a 1/8 royalty on an old lease than you would on a lease taken today, for sure. And that in itself drives a lot of people to at least consider or look around at what their options might be to get out from under that lease and find a new one. Now, I will say that just because your lease is old, that doesn't mean, that's not an excuse to terminate it. But these older leases, kind of like you hinted at, not having a pew clause, or they may not have other clauses. As leases get newer or more recent, you can see a trend where they become more specific, trying to address all the contingencies and sort of the lessons learned over history. If you're looking at a lease from the 50s, for instance, like they tend to be much simpler, much shorter, which is, on the one hand, it's easier to understand as a layperson or a lessor. But on the other hand, they sort of have a lot of blanks that may be filled in with more recent case law that may be to your favor or may not be your favor, just kind of depending on the situation.
Yeah, that makes sense. Okay, well, switching gears a little bit, I want to talk a little bit about funds held in suspense. So I know that I've run into this before, and I wanted to talk to you a little bit about where mineral owners can run into issues with operators in terms of not getting paid. Once an owner has identified producing well on their lands, they're not getting paid for it. What do they need to do in order to protect their rights? And or is anything specific that a mineral owner should do in terms of contacting the operator once they find out they're in that situation?
Sure. I think the first thing is that if you think you have an interest under a lease that is producing, you're not being paid, the first step is to notify the operator immediately that you think there's a problem. You can let them know where the lease is, who you are, and also, what you think is your claim to title for that interest. In other words, you're on the lease, or maybe you inherited your interest from your grandfather, who was the original lessor. Whatever it is that you need to show that you have an ownership interest in that lease, you'd want to put that together and have it ready for them. I think one thing you said there about making sure that your name is on it is one of the most important things. You want to make sure that the operator knows that you believe at least your name should be on there, as it were. In other words, you want them to know that you're one of the people they ought to be paying. The reason that is because in some states, if the operator has a good faith reason to believe that someone else is the right person that should be paid, and they're in fact paying that person, your recourse may be not against the operator, but against the other individual. And obviously, if that's family, which is fairly common, that could create problems. Or it just may be that other person is going to spend the money before you can go and get the problem fixed. So step one is to let them know that you see an issue. Step two, depending again on the timing, is if you get any pushback from the operator, you want to be open and willing to find out what it is that they need to connect the dots on their end. And depending on the size of the interest, what's going on, you may or may not be able to get the attention of the land department at the operator on your own. And so, if that's the case, oftentimes that's where an attorney or another professional can come in and can help you out, because they may have personal contacts that they've dealt with there before that can get you some special attention. Or it may just be as simple as being the squeaky wheel, in that once you raise the flag, or have an attorney raise a flag for you that this is a real issue, then it may start to get spotlighted internally on the other side, and they'll fix it, or at least give you an answer as to why they think you're wrong, and then you can evaluate from there. So those, I think, are the first two things to do. The third thing is more sort of for your attorney. Depending on your state, again, there are various statutory requirements that the operators have when they place money into suspense. So there are reasons why they can and can't do it, and depending on what that reason is, they may or may not owe you interest on the suspended funds. And further, depending on the reason, it may be that the interest is something small, or it may be quite significant. For instance, in Oklahoma, it can be up to 12% interest on suspended funds if the reason that those funds are suspended doesn't fall into one of a few certain categories.
Absolutely. I think that makes a lot of sense. And I know a lot of mineral right owners the interest topic is a confusing one for a lot of mineral right owners. And this is kind of a broad topic to bring up, but for me as a mineral right owner, something I found to be kind of surprising, and I know this is specifically in Texas, but the Texas courts sees it as the mineral right owner's job to be sure that they are keeping up with who is producing on their lands and bringing attention to the problem. Can you talk a little bit about that and how the court views that for the mineral right owners? Because for me, it was kind of surprising that there was such pressure put on the mineral right owner to be sure that this is identified so that you don't run against those statutes.
That's right. So this really, Texas is particularly, I'll say, strict on royalty owners when it comes to the situation. It usually arises in the statute of limitations, which in Texas is 4 years. So if you're due to get a royalty payment every month, you can go back if you file a lawsuit and recover all of the payments that have been missed or underpaid for the 4 years preceding the date that you filed a lawsuit. There are various exceptions to the statute of limitations that may extend that time for you, but they are hard to get, especially in Texas, because the courts and the law require you to be on notice. As a legal concept, it's called constructive notice. But really what that means is that if you could have found out, we sort of charge you, with one, the duty to find out, and then two, we treat you as if you knew, even if you really didn't. So translated into real terms, that means if you're a royalty owner, you can, in theory, you can go to the Railroad Commission, the Texas Railroad Commission's website. You have access to state comptroller records that show what taxes are being paid, and how much, and on what wells. You can see what wells have been permitted. You can find out some production data. You can go in the county records and see whether or not an interest has been pooled, especially your interest. So there are a lot of things that are technically out there in the public record that I think most, if not the vast majority of owners, either aren't aware of, or two, don't really know where to go, where to find them, or how to interpret those records once they have them. Now, notwithstanding the fact that you may need an expert or professional to help you look at that, the courts are going to treat you as if you have looked at those and understand what they mean. So the bottom line is that if you're a royalty owner, you are charged with the responsibility to know what's going on your lease, and to go look at what's publicly available, or if you can't do it yourself, to get someone to go look for you at the records and do your very best investigation. And if you don't, you're going to be cut off from bringing claims for any payments that are more than 4 years old.
Absolutely. And I know for me, that was really eye-opening, because it just is something to really see that the onus is on the mineral right owner to educate yourself, because that's truly what it is. And I know that, again, this might be a loaded question, but in a perfect scenario where a mineral right owner has the boxes checked that they've done everything they need to do, and there are funds being held by an oil company, is that something that typically goes to litigation? Is it typically settled outside of litigation? And if it does go to litigation, is that typically a slam dunk for the mineral right owner, or can it go either way?
I would say that when we're dealing with suspended funds, they're usually suspended for a reason. So especially if you're dealing with a major operator, they suspended them for a reason. So they're unsure about who to pay or what needs to be paid. And so they place them in suspense so that they don't go to the wrong person. The major operators are very aware that if they're paying the wrong people, it can create problems and cause litigation. And it's just an inefficient business practice. So in that case, it is more likely that if you can put your paperwork together and show your entitlement to the interest, and there's no one else, competing for that interest. In other words, you don't have anyone else out there who's claiming the rights to the same portion that you're claiming the rights to, then I think the operator is usually going to be happy to resolve that and put you in pay status once they've got the right documents. Now, if there is someone out there who contests your ownership, then really your dispute is between you and that other prospective owner, not so much with the operator. So in that case, the operator may say, "Hey, look, we're just suspending them, and we will stand by while this gets resolved." Now, if it's something other than suspended funds, it may be more difficult to resolve, and you may have to get either close to litigation or actually file a case to get something moving. And that you generally see that happen more often in cases where you have disputes or disagreements over how cost provisions in leases are to be interpreted. In some cases, it may be that once you bring the lease to the operator's attention, they look at it and they'll agree with the way that you read it. But in other cases, they may not. And again, depending on your state, what a lease says that may appear to be common sense and clear to you can be very ambiguous and uncertain under the law. And so there certainly is room for competing interpretations at times, and those kind of situations may require more before you can get them resolved.
Absolutely. Well, thank you, Spencer, so much for letting us take a deep dive into the world of the mineral rights litigation. And I appreciate so much your effort to fend off "it depends," because I know that can be such a difficult thing in your world because everything is it depends on the circumstances and everything that's going on. I know it's highly valued by our listeners, myself and Matt. If our audience would like to find you and reach out to you, what's the best way for them to get in touch with you?
Sure. So probably the best way is just to call us directly. Our firm name is Burns Charest LLP. The phone number here is 469-904-4551. And our front desk can direct any callers to me. It would be fine. We're also on the internet at burnscharest.com. And then, of course, my email is scox@burnscharest.com. And we're always happy to hear from folks who think they might need help. I'll say that, most people who contact us don't end up really having a case, but they usually have questions that in most times can be answered pretty simply, or at least we can point them in the right direction. And we're certainly happy to do that for anyone, whatever the size of their interest.
Thank you so much again, Spencer, and it's been great to have you on.
Yeah, thanks, Spencer. Appreciate your time.
Yeah, I appreciate it, guys. I really love the podcast, and I think you guys are doing a very valuable thing out there for our owners. So keep up the good work, and thanks for having me.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.